Let us start with the terms legal advisor and legal consultant. These are probably the most generic terms that apply to any person who is giving any kind of legal advice. In many countries, there may be little or no restrictions on who can be a legal advisor or a legal consultant. For example, a person who has working knowledge of tax law or working knowledge of labor law purely because of experience can become a legal advisor or consultant in those domains, even without any formal academic qualifications. However, the scope of a legal advisor who does not have formal legal qualifications may be limited to just providing advice and external support. Such an advisor or consultant cannot represent the clients in formal legal proceedings or represent the clients in the courts of law. The term lawyer is often used in a generic manner to describe anyone who is practicing law or engaged in any job in the legal field. But strictly speaking, a lawyer is a person who has formally studied law, just like an engineer is a person who has formally studied engineering. Some countries like India and the UK have LLB programs, that is the bachelor's degree in law, whereas other countries like the USA, Canada and Australia have the JD or the Jurist doctor program. Anyone who completes an LLB or a JD can be called a lawyer. But just because a person is a lawyer, it doesn't mean that the person is actually practicing law or is engaged in a law-related job. A person can be a lawyer because of an academic qualification like an LLB, but the person could be working as a businessman or as a farmer or in any other job which may not be connected with the practice of law. So, for the sake of simplicity, a lawyer is a person who has an academic qualification in law. An advocate is a lawyer who is actually practicing law and is formally authorized to give legal advice and also to represent clients in the courts of law. Typically, to become an advocate, a person has to first have an academic degree in law, like a LLB or a JD, which makes the person a lawyer. And the lawyer then has to pass a bar exam and register with a bar council as an advocate. In other words, an academic degree makes a person a lawyer. A lawyer who passes a bar exam and registers with a bar council becomes an advocate. While all advocates are lawyers, all lawyers are not advocates. In some countries, the term senior advocate may simply refer to any advocate who has been practicing law for many years. But this term has a special connotation in some countries like India. In India, senior advocate is a title formally conferred by the Supreme Court or the High Courts. The High Courts and the Supreme Court may periodically call for applications from advocates who wish to be considered for the title of senior advocate. The courts will then take into consideration multiple factors like years of practice, the types of cases handled, pro bono work, domain expertise, publications and teaching experiences in the field of law. And the courts may also assess the overall personality and the suitability of the advocates, usually through a personal interview, and then confer a senior advocate title. A point to remember here is that just because a person is given the title of a senior advocate by the Supreme Court, it does not mean that the advocate will automatically become eligible to argue in the Supreme Court. To be able to practice or argue cases in the Supreme Court, an advocate has to be an advocate on record. In the Indian context, an advocate on record is an advocate who is duly qualified to practice in the Indian Supreme Court. As per the rules, no advocate other than an advocate on record shall be entitled to file an appearance or act for a party in the Supreme Court of India, which means that if any normal advocate or any normal senior advocate wishes to appeal to the Supreme Court, they have to engage with an advocate on record. To become an advocate on record, an advocate has to have a certain number of years of practice and then train for at least 1 year with a senior advocate on record and then pass the AOR exam. After passing the advocate on record exam, the advocate has to have a registered office within a 16-kilometer radius from the Supreme Court building and must also engage a registered clerk. Solicitor and barrister are terms that are used to refer to lawyers who are practicing law in England and Wales and also in some other Commonwealth countries. While both solicitor and barrister are similar to an advocate, A solicitor is like a junior advocate and a barrister is like a senior advocate or an advocate on record. Think of it like a general practitioner and a surgeon. Both are doctors. And the first point of contact for any patient is normally the general practitioner, who will take care of the normal medical requirements and do the initial diagnosis and also prescribe any regular medicines, etc. But if the case is complicated and requires some specific expertise, the general practitioner will then refer the patient to a surgeon or a specialist. Similarly, a solicitor is usually the first point of contact for any clients who are seeking legal advice. The solicitors handle the day-to-day legal work directly with the client. They can draft documents like contracts or sale deeds, and they may even represent clients in lower courts like magistrate courts or the county courts in the UK. But if the case needs to go to a higher court like the High Court or the Court of Appeal like the Supreme Court, or if the client requires some specialist advocacy, or it is a complex legal situation, the solicitor will hire a barrister on the client's behalf. On a side note, it is probably easier to differentiate between solicitors and barristers in the UK because solicitors are generally dressed in normal formal business suits, whereas barristers wear the traditional wig and the gown when they appear in court proceedings. In India, this term solicitor is used in the context of some senior law officers of the country who represent the government of India and hold the roles of Solicitor General and Additional Solicitor General. During the British Raj in India, Indian lawyers were referred to as Vakils, and advocates who represented clients in court proceedings and drafted appeals and presented court pleadings were referred to as pleaders, probably because a pleader would plead in court or submit a plea on behalf of a client. Both these terms are now quite outdated and have mostly been replaced with the term advocate. But these two terms are still used by the older generation, who talk about going to a Vakil for legal advice or engaging a pleader for court matters. Surprisingly, this term pleader is still used in the context of government lawyers, who are also called government pleaders, because they represent the state or the government. In the United States, attorney is the standard term for a practicing lawyer or an advocate. Attorney at law means someone who practices law, someone who gives legal advice, and can represent clients in legal or court proceedings. An advocate in India or a solicitor or a barrister in the UK are similar to an attorney in the US. In India, this term attorney is used in the context of the highest law officer of the country, who holds the role of the Attorney General of India. Let us take a quick look at the hierarchy of law firms. In many cases, two or more advocates may prefer to join forces and practice together as a law firm. And law firms are usually set up as limited liability partnerships. And what I am describing here is a very simplified and a very high-level overview of the role hierarchy that is followed in most law firms, especially in the US and UK. The entry-level role is usually as a legal assistant. This is someone who provides administrative and clerical support to lawyers. And the work may involve typing documents, scheduling meetings, organizing files, and managing client communication. The legal assistant may or may not have any formal legal education or formal legal training. The role is called a legal assistant simply because the person is assisting lawyers. The next level is paralegal. A paralegal is a person who is trained in legal matters, but usually not a fully qualified lawyer. Typically, a person who has completed the academic requirements like an LLB or a JD and is preparing to take the bar exam in the future will be working as a paralegal in a law firm. A paralegal performs legal work under the supervision of a lawyer. It might be work like research, drafting documents, and case management. In the UK, once a person has completed their academic requirements, it is mandatory to work as a trainee solicitor, usually for a period of 2 years, to gain practical experience before qualifying as a solicitor. So in UK law firms, you will see trainee solicitors one level above the paralegals. However, since the trainee solicitors are not yet qualified to represent clients, their work would be similar in nature to what is being done by the paralegals. Once a person becomes a fully qualified attorney, solicitor, or advocate, They start as an associate and they progress from a junior associate to senior associate. Or it might also be first year associate, second year associate, and third year associate. The next step for an associate would be to become a partner. A partner is a senior lawyer who has ownership or equity or a senior stake in the firm. Partners are responsible for bringing in business, managing client relationships, overseeing teams, and the overall direction and profitability of the firm. At the top of the hierarchy is the name partner. This is a partner whose surname is part of the law firm's official name, like Mr. John Smith in Smith & Jones LLP. Being a name partner indicates that they are a founder or a very senior, influential, or a long-serving partner who holds significant weight within the firm. While this is a simplified version of the hierarchy of a typical law firm, in large law firms, there will be several other functional designations and role titles that may be used to further divide the seniority. For example, some of the senior associates may be promoted as managing associates, a role in which they get to manage a team of associates or paralegals. And partners may be classified as junior equity partners, senior equity partners, and some of the senior equity partners or name partners may be managing partners. And some of them may hold the offices of the CEO, COO, or the CFO of the firm. In the legal context, counsel is a general term that refers to the role of a person when they are providing legal advice. The difference between a counsel and a normal legal advisor is that a counsel has some formal academic qualifications in law, like an LLB or a JD, along with experience or expertise. Whereas a normal legal advisor may not have formal academic qualifications in law. Now, companies may also have legal counsels, who are persons providing legal advice on the company's matters. While the role of a counsel is typically to provide advice, the counsel can also represent the client in the courts of law if he or she is also an advocate. In other words, all advocates can be counsels because they can provide legal advice. But a counsel can be an advocate only if they are duly registered with the Bar Council as an advocate. In a court, when the judge uses terms like the counsel for the plaintiff or the counsel for the defendant, the judge is referring to the advocate or the team of advocates who are providing legal advice to the plaintiff or the defendant and also representing them in the court proceedings. A standing counsel is a lawyer or a law firm retained by an organization like a government department or a company on an ongoing basis to handle their regular legal work whenever needed. The idea behind having a standing counsel is to have a designated lawyer who is already familiar with the organization's functioning and legal issues. That is, to have a lawyer who is ready to handle matters as and when they arise, without needing a separate hiring and vetting process each time. Now, what is retainership? Well, it is just a commercial agreement between a standing counsel and their client, where the client pays a regular fee, usually every month, as an advance or as a retainer fee. You can say that the retainership is like a minimum fee that is payable regularly to ensure that the standing counsel is always available on standby. Some routine and repetitive legal services are covered by the retainership amount, and any additional legal work or any court appearances may be billed extra. A lawyer who works directly for a company or an organization as an employee and handles their legal matters internally is an in-house counsel. Because the in-house counsel is employed full-time with the company, they may not handle any other or external clients. And also because they are employed full-time, they are not registered as advocates because of Bar Council rules in countries like India, where advocates cannot be engaged in any other business or profession, and full-time employees of any organization cannot enroll as advocates. Large companies may have several in-house counsels, one for tax law, one for labor law, one for data protection law, etc. In such a situation, there will be the need for someone to manage all of these in-house counsels, and this is where a general counsel comes in. A general counsel is typically a senior lawyer who heads the legal department and manages all the in-house counsels. Some government departments, banks, or companies employ legally trained personnel full-time to manage repetitive legal work, and this person is called a legal officer. For example, a bank which gives out home loans will have to check the property documents of every applicant and draft loan agreements for every approved loan. In such a situation, the bank may hire a person full-time to do these repetitive tasks. While most companies may prefer an academically qualified lawyer for legal officer positions, some companies may hire just on the basis of experience. The difference between an in-house counsel and a legal officer is that a counsel gives legal advice on various legal matters and may have to deal with different types of situations, whereas the legal officer handles repetitive business processes which are legal in nature. A chief legal officer is typically the person who heads all the legal functions of a company. The CLO will usually report directly to the CEO of the company. In some organizations, the chief legal officer may also be the general counsel. As the CLO, the person will be the manager for all the legal officers and will therefore oversee all the regular, repetitive and normal legal functions. As the general counsel, the person will advise the company on the legal aspects of the company's plans and strategies and also oversee the work of all the in-house counsels. These days, most medium and large organizations have a dedicated compliance officer and a data protection officer. A compliance officer is an employee within an organization who is responsible for ensuring that the company follows all the applicable laws, regulations, industry standards, and internal policies. For example, making sure that a financial services company complies with all SEBI regulations. And a data protection officer, which is often a mandatory role under laws like GDPR or India's Digital Personal Data Protection Act, is a person within the organization who is responsible for overseeing an organization's data protection strategy and in ensuring compliance with all applicable data privacy laws. For example, a data protection officer must ensure that customers' personal data is collected, stored, and used legally and securely. While both these roles, compliance officer and data protection officer, involve significant amounts of legal work, it is not mandatory that only lawyers need to be hired for such roles. Any person with relevant experience and expertise may be hired for these roles. However, many organizations do prefer to hire lawyers for such roles. A notary or a notary public is a person authorized by the government to witness signatures, to verify identities, and to certify documents as authentic. For example, if some official document has to be attested by a notary, the parties have to visit the notary's office, who will verify the identity documents of the parties to validate that they are who they claim to be. And then the notary will witness the signature of the parties on the document. The notary will then sign on the document, put the date, and also affix their official stamp to formally attest that the document was signed in the notary's presence. To become a notary in India, a person must be an advocate. They must have practiced for a minimum number of years as an advocate and must apply formally to be appointed as a notary. And the appointment and the functioning of notaries is governed by the Notaries Act. Though we normally don't come across this term so frequently, there is another legal role called the Oath Commissioner. An Oath Commissioner is appointed by the High Courts or the District Courts under the provisions of the Code of Civil Procedure. Now, the primary function of an Oath Commissioner is to administer oaths and to verify affidavits and also to affirm statements for legal proceedings, which means that the jurisdiction of the Oath Commissioner is limited to the matters pertaining to the court of appointment or within a district. And also the scope of work that can be done by the Oath Commissioner is quite limited because unlike a notary, the Oath Commissioner cannot authenticate documents and cannot notarize documents for international use. Recently, I came across a news article about the alumnus of one of the NLUs being designated as a King's Counsel in the UK. So, what is a King's Counsel? This designation is used in the UK and some Commonwealth countries where the titular head of the country is the King or the Queen of the United Kingdom. When Queen Elizabeth was the monarch, the designation was Queen's Counsel, and since King Charles is the current monarch, the designation is King's Counsel. KC or QC are similar to a senior advocate designation in India. A senior barrister or sometimes an experienced solicitor who is recognized for merit and for legal expertise is awarded this designation. For example, a top barrister in London, known for handling high-profile cases, may be appointed as the King's Counsel. Who is a prosecutor or a public prosecutor? First of all, when we talk about an unlawful or an illegal act, there can be two types of wrongs, civil wrongs and criminal wrongs. A civil wrong is a wrong committed against a specific person or a specific set of persons, like a breach of contract or a tort. On the other hand, criminal wrongs are illegal or unlawful activities committed against the society in general or against the people of the country. Since criminal wrongs like murder are crimes against the society in general, the state or the government will be the party on one side who will seek to convict the accused. So, a prosecutor is a lawyer who represents the government, that is, the state or the people, in criminal cases. And the prosecutor tries to prove that someone accused of a crime is guilty. For example, in a murder trial, it will be the prosecutor or the public prosecutor who works towards proving that the accused person is guilty of the crime. Who is a public defender? A public defender is a lawyer employed by the government or a non-profit organization to represent people accused of crimes, but cannot afford to hire a lawyer to defend them. The role of a public defender is based on the simple premise that if someone is accused of a crime, then that person should get every opportunity to defend themselves. But what if the accused person is poor or bankrupt or an indigent and cannot afford to hire an advocate to defend them? In such a situation, the public defender will work to defend the accused. The term public defender is mainly used in the United States, and India has a legal aid system fulfilling a similar function. If you look at the cases from all the different courts and the legal forums from across India, you will find that the government is the biggest litigator, and almost 50% of the cases in the legal system involve the government. In such a situation, the government needs to have plenty of practicing advocates to represent them in various courts. So, a government pleader is a lawyer appointed by the state or the central governments to represent them in civil cases. In India, the highest law officer who advises the central government and represents it in important legal matters, especially in the Supreme Court, is the Attorney General. The second highest law officer who assists the Attorney General is the Solicitor General. Apart from the Attorney General and the Solicitor General, there are several additional Solicitor Generals who assist the Solicitor General and represent the central government in different high courts across the country. Just like the central government has an Attorney General to represent them, the state government has an Advocate General. An Advocate General is a legal advisor to the state government and also represents it in important legal matters, especially in the High Court. Judge Advocate General or JAG is the senior most legal officer within a branch of the military, like the Army, Navy or Air Force. Sometimes this term, JAG, is also used to refer to the complete department which supports the Judge Advocate General. JAG oversees the system of military justice, including court-martials, and also advises the military personnel on their day-to-day legal matters, including advising the Chief of Army Staff. The role of a Judge Advocate General and the department that supports this role is required because there are many laws, rules and regulations that are specific only to the armed forces. You will come across this word jurist or eminent jurist in various articles and books. So who is a jurist? Simply put, a jurist is an expert in law, someone who is well known for their deep legal knowledge, scholarship or significant writings in the field of law. This term is often used to describe eminent lawyers, judges, law professors, or legal thinkers, people who have contributed significantly to the development of important legal principles or to the academic and theoretical side of law. Jeremy Bentham, Hans Kelsen, and Hugo Grotius are some of the jurists whose contributions are studied by law students from across the world. Nani Palkhiwala was considered as one of India's greatest jurists for his understanding of constitutional law. And he was also the lead counsel in several landmark cases like the Kesavananda Bharati case, the I.C. Golaknath case, and the Minerva Mills case. A judge is an official appointed to preside over court proceedings, to listen to evidence and arguments, to interpret the law, and to make decisions, that is, to pass judgments or sentences. The role of a judge varies depending on the legal system. In places like the UK and US, which follow the adversarial system, the judge acts like a neutral referee in the court. Lawyers for both the sides present their case to a jury. The jury decides the facts based on the evidence presented. The judge then applies the law, that is, decides the sentence based on the jury's decision. In places like continental Europe and India, which follow the inquisitorial system, there is no jury. Here, the judge takes a more active role in the court proceedings. Both the parties argue the case and present the evidence to the judge. And the judge finds the facts, applies the law, and decides the outcome, including the sentence. Justice is the title given to judges serving on higher courts, like the High Courts and the Supreme Court. The senior-most judge in the High Court is called the Chief Justice of that High Court, and the senior-most judge of the Supreme Court is called the Chief Justice of India. The term magistrate is used in many countries across the world, and the role of a magistrate also varies depending on the context and the legal system. There are two main categories of magistrates in India: judicial magistrates, who are part of the judiciary, and executive magistrates, who belong to the executive branch of the government. Judicial magistrates are part of the judicial service. Their primary function is to handle the trial of criminal cases, to pass judgments and sentences, and also to handle various pre-trial procedures. In metropolitan areas, there are metropolitan magistrates, chief metropolitan magistrates, and additional chief metropolitan magistrates. In non-metropolitan areas, there are judicial magistrates second class, judicial magistrates first class, subdivisional judicial magistrates, and chief judicial magistrates. The limits in terms of the fines that they can impose and the number of years of imprisonment that they can award will depend on the level of the magistrate. Executive magistrates are part of the executive branch and not the judiciary. They handle administrative activities and also preventive measures aimed at maintaining public order and peace. Within executive magistrates, there are different levels like district magistrates, also called the district collector or deputy commissioner in some states, and subdivisional magistrates.